Today is Wednesday, August 17th. Calling this a meeting of the Wayne County Ethics Board into session. The time now is a little after 9. We're now in session. Good morning, Miss Spivey or Miss Lewis. Does anyone can take a roll call for us this morning?
Mr. Young?
Present.
Mr. Schaefer? Ms. Lewis is absent. Ms. Hammoud?
Good morning, present.
Dr. Carnell? Vice Chair Thomas? Chair Pinkins?
Present.
You have a quorum present.
Thank you for that. Moving right along, again, good morning, everyone. Thank you, everyone, for being here. Moving right along into our agenda. Item B on the agenda is approval of the June 8th and the June 2022 and July 20th, 2022 meeting minutes. As we all know, the past meeting, July 20th, was held, but we did not have a quorum. So that meeting was not able to adopt the meeting minutes from the June 8th meeting. So we have both meeting minutes combined. I assume at this point, everyone has a copy of both meeting minutes and have had the opportunity to review both of those copies. And if there's no objections or any questions regarding any of the meeting minutes, I'll accept the motion to adopt the meeting minutes from the June 8th, 2022 and July 20th, 2022 meeting minutes. Is there a motion? Thank you, Mr. Schaefer. The motion is to adopt the rules. Is there a second?
I'll second that motion.
Thank you, Mr. Thomas. There's a second. All in favor?
Aye.
Aye.
All approved? I mean, excuse me, all opposed? The ayes have it, so moved. Moving on to the next item of business, which is item C, which is our unfinished business. We have item number 1, an update from the subcommittee regarding amendments to the ethics ordinance. I think this is being chaired by Mr. Thomas. Mr. Thomas, do you mind updating the board at this time regarding your subcommittees, the subcommittee meeting for the ethics ordinance, the amendments that you guys are working on?
Gladly. At our last meeting, at our last Zoom meeting in July, we completed our review of the last round of proposed changes that I believe that committee was chaired by Dr. Carnell, or that she was responsible for putting them together. We adopted the vast majority of those recommendations. However, we did tweak them a bit. We made some suggested changes, and then we made some new changes on our own. We're not finished with our work because there were 3 new matters that we needed to discuss. That first was the board's investigative authority. Second was the potential disqualification of a board member. That would be one of us. We don't really have a procedure for that now. And then the third was conflict of interest. Well, I had put together and circulated an email with some language concerning conflict of interest, and I don't think we really got to the point where we were going to vote on that. One of the members, Mr. Schaefer, suggested that he believed it would be in everyone's best interest on the subcommittee if, after all of our work were done, if Mr. Longstreet put together a new package that contains all of the Dr. Carnell's group's changes, all of our changes to those changes, whether they were new or to adopt or tweak in a minor matter, and then our new changes. I really believe, though, that one of the big areas, one of the remaining out of the 3 areas that we're still discussing is the question of investigative authority. We had some new issues come up. One was, first of all, there's an issue concerning who would do it, who would be responsible for it. Secondly, who would pay for it? You know, where would the resources come from? And then a question came up, and I honestly don't recall who raised it. It may have been me. I didn't note that. But I raised a question as to whether, when we have a hearing, what impact there is that our witnesses aren't sworn. They're not sworn to tell the truth. And I don't really know if we would have authority to do that. I don't know. I'm not sure of that. Mr. Longstreet was going to look around and find out what other counties do. But it struck some of us, including me, that when we have somebody in to testify, on occasions where we have hearings, they're not sworn. And I have always felt, and I think the other subcommittee members also felt, that that's significant. So those are the matters that we have to discuss now. In terms of time frame, we have a meeting next week on Thursday of next week. And I'm not certain that we're going to be able to finish up our work at that meeting. It all depends on how long we go. But I would think that if we don't finish up our work at our meeting next week, that when we schedule our meeting for September and hold that meeting, I think it would be realistic that we could finish it by that time. But I can't make any guarantees regarding our meeting next week because these areas that have been put off for discussion are really some of the most important critical areas that I think we all felt needed to be discussed. And collectively, I think we may have felt that would be good to get through the original draft and then deal with these areas. So we have some work to do. That's the short of it.
Thank you, Mr. Thomas. And let me just ask you this from the chair. You mentioned investigatory powers. I'm assuming you all have looked at other ethics boards in the county areas, various counties, to see if they have investigatory powers as well.
I believe that Mr. Longstreet is in the process of doing that. He's nodding his head. He agreed that he would do that after our last meeting. So I assume that when we meet next week, he'll be updating us on that.
Mr. Longstreet, tell me, do you, as the attorney for the board, have any investigatory powers? Within our procedural operations, is there any investigatory powers within the nature of your work that you do?
It seems like there is some presumed investigatory powers that allows me to issue subpoenas on behalf of the ethics board and once directed, ask that witnesses appear. But however, the detailed investigation that I would like to do in regards to violation of the ethics orders, fact investigations, that is not a part of the statute and or the rules of procedure for the Wayne County Ethics Board either. And I think they should be included.
So do you have the ability to send investigators out to do any sort of investigation or anything like that?
Not at this juncture, no. And I think that should be pertinent to any function of the ethics board, is to be allowed to investigate complaints. I have had an opportunity even before the ethics, when the subcommittee was first put together, I did do a research of different counties within the state of Michigan and other states to see what the investigatory powers were of the ethics board, and they're far more expanded than those here in Wayne County.
If I may,
Mr. Thomas.
Chairman, you know, one of the things that has struck me is that I think that the procedure now presumes that the complainant, whoever that person is that files the complaint, that they're going to do the investigation for us. I mean, they're going to bring in witnesses. They're going to question witnesses, and the respondent, of course, would have the right to call his or her witnesses. So hopefully, somehow in the mix, the truth of the matter might come out. And I think that really assumes that whoever the individual is that files a complaint is going to be familiar with prosecuting a complaint, have legal skills, be able to figure out what the burden of proof is and all of that. And I would really say that at some point, at some juncture, we should have that authority. We shouldn't be in a neutral posture where we have to depend on other individuals. And I think that one of the things that we're going to have to discuss is when we make suggestions concerning changes that would include investigatory authority and funding for that. I think we have to stress to the commission that's going to be reviewing our request how important that is. We want to be a very vibrant organization. If there's a hearing, we want both sides to have a fair shot at telling us what happened, what didn't happen. And I think to do that, I really think we need, there has to be some provision for investigative authority. I really do.
So, and thank you for that, Mr. Thomas. So what I'm hearing is possibly in putting some sort of investigatory ability for this board in the ethics ordinance. My concern is, and these are amendments that we're making, we're potentially suggesting that the commission adopt. If those are not adopted, then we still have no investigatory powers whatsoever. With respect to our procedural operating procedure, Mr. Longstreet, is there something, and I'm sure you have copies of that, is there something we can add, possibly by way of motion and vote, into that operating procedure under the attorney for the ethics board to sort of expand your authority to do some sort of investigatory, take some sort of investigatory action with respect to complaints?
I believe my only issue with that would be how is it enforced by law? Because if it's not law, then no one has to comply with it. It's just simply a statute. Well, it's not a statute, it's just simply an operating procedure. So if it's only in the operating procedures, how do we actually enforce the investigative powers if it's not law? I think this will require legislative change.
I can agree. Do we do both, or do we just do one or the other? Or the more of the law situation, the law aspect of it?
I would say the law, because you can do both so that any future person in my position has some level of guidance in regards to what to do or what their powers are. But I think in order to be able to enforce it, it has to be law.
All right, well, thank you so much for that. I'm sure you guys are gonna continue your work there, and we thank you for your due diligence in working on these amendments. I will ask also, how soon do you all think that you can have some sort of draft proposal ready for this board to look at and possibly vote on? Mr. Longstreet.
I've begun the drafting of the amendments that have been done by the subcommittee at this point. I plan to have a fully updated ethics ordinance to the subcommittee by our next meeting. The only addition being the conflict of interest, the disqualification of a member. That language has yet to be added because we haven't finished the fine details of what those provisions should say. But everything else should be included, and we should be prepared to provide something to this board incomplete by October 1st, I would imagine.
October 1st?
Yes.
That will be
Chairman, that would give us 2 meetings. I believe that's realistic. That would give us our meeting next week and then a meeting in September once we schedule that. I think that's realistic.
All right, good. Well, thank you all for that update. Yes, Dr. Carnell.
Thank you, Chair. I appreciate Mr. Thomas giving me credit regarding the amendments to the ethic ordinance. I just want to reflect that was a collective effort of the ethics board at that time.
I think Mr. Thomas wanted to make sure, Dr. Carnell,
I stand corrected.
It was a collective effort, but Dr. Carnell, I think you did lead the way, and you sort of spearheaded it, and I think we all appreciate that. So thank you so much for that. All right, moving right along, the next item of our agenda, item number 2, under unfinished business. We have a discussion concerning the dissemination of closing/dismissal letters in situations where the board is not going to take action on a complaint. Question has recently arisen as to whether the complainant should be provided a copy of the closing letter issued to the respondent, and whether the respondent should receive a copy of the closing letter issued to the complainant. Obviously, this was some discussion taking place at a prior meeting. I'm going to let Mr. Longstreet open this up with discussion. If you can, Mr. Longstreet, I think that came up with the letter that we have regarding a complaint. I believe it was against someone in the sheriff's department, and there was a response to that complainant. I'm going to let you open it up and lead the way on this, sir.
I believe that there should be, for purposes of transparency and government function, I believe that the letter should be disseminated out to all interested parties. Mr. Thomas and I had discussions in regards to this specific issue. For instance, in the Attorney Grievance Commission, when there is a complaint filed, both the respondent and complainant both get copies of all the correspondence. I think for purposes of transparency and fundamental fairness, I believe that I should be able to disseminate the letters to all parties.
Any further questions from any members?
I don't have any questions. I would say that when the issue arose, it arose because we were contacted by Reverend Taylor, who is in the audience today. And we sent him a closing letter. Ms. Hammoud had made a motion that certain language be included in the closing letter that went to him, and as well as the letter that went to the sheriff's department. And we agreed at that meeting that Ms. Hammoud and I would approve the letter, the format, and that we would get back to Mr. Longstreet on it, and that's what we did. And the letters were sent out. Well, it was subsequent to that Reverend Taylor contacted Mr. Longstreet and myself by telephone and requested a copy of the letter that went to the sheriff's department. He wanted to know what was said in that letter. So that's how we got here today. And I will tell you, I did have that conversation with Mr. Longstreet about the practices at the Attorney Grievance Commission for the near decade that I was there. Better yet than sending a copy of each letter, normally it was just one letter that explained everything concerning why a file was being closed, why no action was being taken. So, but there are occasions where we're going to want to include special language to a complainant or the respondent. So if a motion is needed concerning what Mr. Longstreet has now recommended, that the letters be sent out to both sides in that situation where the sheriff's department got a separate letter, I make a motion that it be copied to the complainant. And when a letter is sent to the complainant, I make a motion that letter be sent to the respondent. So I think that transparency is always important. Anybody is going to want to know what was said to the other side concerning the complaint that they filed. So I think if a motion is needed today, I would make that motion. And I would further say that in the event that somebody feels that our code, the ethics code, should be amended to provide for that, I don't think it needs to be. But if someone feels that it needs to be, I'll make a motion. I'll make that separate motion.
I would make the recommendation that it just be part of that be the standard operating procedure of this board, that upon issuance of letters, that all letters go out to all parties so that in the future we have consistency in our processes.
And you feel that that would be sufficient? We wouldn't have to amend the ethics code, the ordinance?
I don't think the ordinance speaks as to, well,
Okay.
it does.
All right, excellent.
But I think at some point there each should be in the ethics code itself and or the rules of procedure of the Wayne County Ethics Board, or added to both, so that future parties know exactly what to do in these situations.
Well, I'd amend my motion to say that it should be included, that the language should be included in the procedures then.
We have a motion on the floor, but before we get to your motion, Mr. Thomas, what I want to ask a quick question. If I'm not mistaken, the letter from Mr. Taylor, the complaint from Mr. Taylor was dismissed for lack of jurisdiction. So are you saying that anytime we get a complaint that goes no further than your office, then whatever letter you send to that complainant should also go to the respondent who would have been a respondent of a complaint that the person never knew about because it never really came before this board because we dismissed it for lack of jurisdiction? Are you saying that basically you're giving notice to anyone who has a complaint filed, but no action is never taken in that complaint? So you want to give notice to anyone. So when you're mentioning the attorney grievance board, generally, I think that's when some action is being taken. There's a grievance filed against a particular attorney. The attorney grievance is going to look at that and look at it and weigh it They're notifying that particular attorney to let them know that there's been a grievance filed against you. Provide us with certain documents or give us your end of what you think took place. And those documents are disseminated between both parties. They're taking some action. But if they receive a grievance that they decide to take no action on, that they just say, no, this is just not even worth our time, and they just dismiss it, I don't think that attorney is ever notified that there was a grievance filed. Or if the grievance comes in and it lacks something that the board would need to pursue an investigation or something, or open up a file or a case on that particular attorney, if it doesn't comply, does that attorney ever even hear that a grievance was filed against them?
Well, by court rule, they have to be notified. So in that situation, in the situation that you've just mentioned, if an individual filed a complaint against a lawyer and the complaint concerned, let's say, a fee dispute, and the Attorney Grievance Commission was going to close that because they believe that that's a dispute that should be resolved within the civil court system. People want to fight over what the fees should be or what they shouldn't be. That should be resolved by a judge or a jury. That same letter that went to the complainant notifying the complainant of that would be copied to the lawyer. The lawyer not only gets notice that no action is being taken, but Chairperson Pinkins, they get a copy of the complaint that was filed. You know, that's provided by court rule. And again, that's transparency. So that's what I was working on. And I will tell you, even when I represent individuals before the state medical board or the boards that oversee accountants, they get notice that a complaint was filed. I think that there's just an inherent belief that they're entitled to know that a complaint was filed and nothing is being done about it. So.
Thank you for that, Mr. Thomas. I think Ms. Hammoud, I think you've been.
Yeah, I think we have a motion and I would like to second the motion.
First off, let me read the call of the motion. So, Mr. Thomas, again, we're going to get back to your motion. And I think if I'm not mistaken, you might have made two motions. So state the first motion again, and I'll state the call of that motion.
Well, to refine it, to try to get the exact words that I said before as best I can, I would make a motion that when a complaint is received and no action is going to be taken by our board, we make a determination that we don't have jurisdiction, that should be closed, dismissed, whatever terminology is going to be used, that the complainant be notified and that the purported respondent, who no action is going to be taken against, just the individual that was complained against, that they receive a copy of that letter. That's motion number one. Now, do you want me to get into motion number two?
Let's deal with motion number one. So
okay,
with
motion
respect
number one.
With that's the motion that's on the floor. So the motion on the floor is Mr. Thomas made a motion to move that we adopt where if a complaint is filed, no action is taken, that not only does the complainant receive a copy of the letter stating no action is being taken for whatever reason, and also the particular respondent of that complaint also receives a letter that no action is being taken or whatever action this board decided to take. That is the motion that's on this floor at this time. Mr. Thomas, you had some discussion on that, so I don't think you need any additional discussion if you need.
I have a question.
Yes, Dr. Carnell. Well, we are opening this motion up for discussion at this time. So Dr. Carnell, I'm going to let you go.
How does this play on confidentiality or whistleblower act?
I'm sorry, I didn't hear.
How does this play on whistleblower act or confidentiality or privacy for the person who made the complaint?
So that's a good question.
Yes,
but I
Dr.
thought,
Hammoud. Excuse me, Mona Hammoud. Yes. Ms. Hammoud, go.
yeah, I think the way it's written here, if you file a complaint, you have to, like, if we want to do hearing or anything, it's the responsibility is on whoever filed that complaint to come and give us. I don't think right now they can do that anonymous. I think the only thing that if they're asking for recommendation or some letter, but if it's a proper complaint, on the form, they can't be, and I know we discussed this before to try to see if there is a way for, such, a way to remain anonymous, but I don't think right now the way the ordinance are written, and that will be then, again, a code that needs to be approved by the, legislative body. If I remember correctly, but I'm gonna go to Longstreet here.
If I may, I do believe 40.7 in regards in the statute does allow a complainant to make a complaint anonymously. Also, page 2, page 3, subparagraph advisory opinions, subparagraph B, complaints may be made anonymously. That is part of also the operating or the rules of procedure for the Wayne County Ethics Board. So I do, in regards to the privacy aspect of it, I do believe there is some provision for the complaint to remain anonymous.
So how would that, Mr. Longstreet, so how would that work in this situation then? If a person files a complaint against a person, they want to, particularly if it's not going to go anywhere, they want to remain anonymous. How would that happen? Or how would they go about doing that? And
just simply leave their name out of the correspondence.
But you have to sign it. It has to be certified. It has to be notarized, the complaint. So how does that work?
I would imagine I would have to take it upon myself to redact or exclude that information if that person chooses to remain, the complainant wants to remain anonymous. I think it will be up to the attorney to take the proper action to ensure that that person's wishes are fulfilled and that that person's name and or identity remain anonymous.
Does the general public know that there are options to file a complaint anonymously? And that's another issue I'm concerned about. I don't think the actual layperson really knows that or have idea. I think a person goes to our website and finds a complaint, goes through the procedures, files a complaint. They may want to remain anonymous, but is there something there that states to them that if they wish to file a complaint anonymous, that they can do so?
I'm unsure whether the website provides that information or not. I think it will be, and I think most people that are filing, from my experiences, I've been here for the last 6 months, that they're laypersons. They don't have the expertise of going through the statute and find out specific information they would need to properly file a complaint. So I think it should be in the forefront that they should be told that they can, if they choose to, remain anonymous, keep their identity to themselves. Because I think a lot of people, especially if they're filing complaints against their bosses, they would fear retaliation if their name is known. So I think it would be pertinent to keep their identity anonymous until a certain point where it has to be revealed to the responding party.
Now it sounds like we're talking about getting back into the language on the website. I think we got to that earlier in the year where we had added some additional language to the website. That should possibly be something that's on the website explaining the complaint process. It should be language in there, alerting a person to the fact that they wish to file a complaint anonymously, that they can do so, and the provisions in which to take to do that. I think we're sort of opening up some other worms here, and then that's where I think we sort of we get to when we start doing this. Yes, Ms. Hamoud.
Yes, as a follow-up, I would like to get an opinion from our attorney then, because I know we discussed this previous year, and because of the Open Meeting Act, there were like kind of conflict of like we would have to disclose. And now, like, I'm hearing differently. So I would like to get, an opinion for our record to know that, to your point, what we can do and what we can to make whoever filing a complaint anonymous. And if there is a way, then definitely, I know Mr. Thomas put the motion, but I'm willing to suggest if you would like to amend the motion in case it's anonymous, then that's definitely, like, especially if we dismiss it, we don't have to let the other party know. But I mean, as far as I know, I think we should table this then for another meeting to get the information if anonymous complaint can even be processed.
Before we get to that,
Yeah.
we're still discussing this motion at this time. And
Right.
thank you for that, Ms. Hamud. But what I'm going to also add too is that once a person files anonymously, then you obviously notify the respondent of whatever action is taken, one way or the other. At that point, you're not notifying the respondent of who the complainant was. If the person filed anonymously, then you're just allowing them, letting them know that a complaint was filed. Can they then wish to ask who filed it? If that's the case, or you just say that the person wanted to remain anonymous, so therefore you could not provide that information. These are some areas I think we need to research before we sort of get into this and put it in stone. But again, Mr. Thomas, you have your motion on the floor. We're still discussing your motion.
Well, I want to withdraw the motion. I think that the suggestion that Ms. Hamud has made, that it be tabled for an opinion from Mr. Longstreet, I think that that's the prudent course to pursue. Because I will tell you that in my discussions with Mr. Longstreet, my discussions with Mr. Taylor, his was not a situation where he was asking to be anonymous, and it just didn't arise. So I think that in light of the discussion today, I think that I want to withdraw the motion. Let's be prudent. Let's get an opinion from our counsel.
Okay, so Mr. Thomas has made a motion to withdraw his motion that we adopt language to send out a letter to any person who has filed a complaint to also notify the respondent of that complaint of an action or any inaction on that complaint that was filed. He's filed a motion. Motion has been made now to withdraw that motion. Is there a second to that motion to withdraw Mr. Thomas's original motion?
I'll second.
Favor?
Aye.
So moved. Motion has been withdrawn. Okay, I would take it that Mr. Longstreet, you're going to do some research into these matters and advise this board.
Absolutely.
Thank you, Mr. Longstreet. There's no further discussion on that matter. I'm going to move on to the next item of our agenda, which is item number 3. Discussion on the response from the Sheriff's Office regarding a complaint filed by Reverend John W. Taylor. Did we get a response from the Sheriff's Office regarding the complaint? I think
Through the chair, this is Tim Johnson, Director of Administration. I did reach out to the Sheriff's Office and did get a response. I'd like to read that response into the record.
yes, go right ahead, sir.
It's from Chief Robert Dunlap, who is Director of Jails. Good afternoon, all. Please be advised that both the sheriff and I have addressed this matter with Mr. Taylor on several different occasions. We also advise Mr. Taylor he has to follow the same rules as all other volunteers and that he does not have a right to perform religious services in the jails. End of email.
Mr. Taylor, did you hear that, sir? Yes, we're going to give you time to respond to that because there was a letter that was read. Obviously, the person who sent over the letter is not here to give any further feedback unless, sir, are you prepared to give any feedback if you ask for any feedback, sir, or are you just reading the letter? Into
Just reading the letter, yep.
Thank you, sir. Mr. Taylor, you heard the record, you heard the letter. At this time, if you would like to respond, you can, sir.
Good morning, Wayne County Ethics Committee and Chairperson. Good morning. Sir, you were not here at the last meeting. Can I give you a brief update of what I said then?
Sure.
I've been a volunteer minister at the Wayne County Jail for about 35 years. Had no issues whatsoever when we have to renew our clearance papers in order to get in. Not until this past summer, we had about 5 different documents that we had to agree to, be bound to, and sign before we were permitted to go into the jail. About 3 of the documents I didn't have any problems with because they were provided to us. We were able to read them, understanding, possibly ask questions. So I signed those. But there's one particular document, literally, it was about 1,100 pages long. It's a kind of NCII manual that we had to agree to and be bound to. And I asked the Sheriff's Department, can we see this document that you're talking about? Only way I got the chance to see it was I Googled it and found out it was that lengthy. And then so much of that information does not even apply to volunteers. So basically I was asking, can you kind of pull out what is specifically applicable to us, the volunteers, before I agree to sign this? I contacted Sheriff Dunlap. I contacted the secretary of the sheriff of the department, and they say, we thank you for your years of service, but if you change your mind, you can just fill out the paperwork. And I thought that this was just unethical to have people expected to sign something that they haven't seen, they don't understand, and doesn't even apply to them. That's when I filed a complaint with the Ethnic Committee. And as a result of filing that complaint, last meeting, Vice Chair Thomas, he asked the attorney of the Wayne County Commission, Felicia Johnson, to see me after the meeting. She did come over, and basically she was going to direct her attention to 2 questions. If this ethnic board does not have the jurisdiction to deal with this kind of situation, who does? I was told by Attorney Longstreet as well as Attorney Thomas that the voters do. I'm not asking for the sheriff to be recalled. I'm just asking them to deal with the procedure issue. But anyway, Attorney Johnson, she was supposed to help find out who has jurisdiction in a situation like this. She was supposed to get back with me. I called her 2 different occasions, left voice messages, never heard from her. She also was supposed to check with the Wayne County Commission to find out if they had jurisdiction over something like that. Again, I heard nothing from Ms. Johnson. So we're talking about jurisdiction on one case, who has the jurisdiction if the ethnic board is not able to do anything. Secondly, we're talking about what can be done where the sheriff department can plainly see that volunteers should not be held accountable for reading and understanding an 1,100-page manual and agree to be bound by it without them just condensing that where it applies strictly to volunteers. So those are the 2 issues that Felicia Johnson was supposed to deal with. Is she here today, Mr.
No, she's not.
She's not, okay. Do you know why she didn't respond to my voice messages?
Well, sir, we don't, let's not start getting into questioning, because I think.
I'm sorry,
This
excuse me.
gentleman here, I'm not sure he can speak for Ms. Johnson.
Well, I got her number from him. That's what I thought I could ask. So, but basically, Mr. Chair, those are the issues there. The jurisdiction, because I know they say that he is an elected official. And technically, when you look at it, he was appointed official. We know that when Sheriff Benny Napoleon died, he was appointed by what I understand, a 3-person panel, the Wayne County clerk, the Wayne County prosecutor, and a Wayne County judge. He was placed there without voters giving him that office. But still, that's beyond the point. The point is, if this board does not have jurisdiction in this area, who does?
That's a good question. And I'm going to thank you for being here. Thank you for taking the time, because obviously this is a serious concern for you, because you would not be here today. I know you was here at the prior meetings and that you did file a complaint. So this is something, a very serious issue to you. And I thank you for being here, and thank you for coming before this body and bringing this to our attention. I do think Mr. Longstreet did address your complaint. Let me just ask you this. I think what you're getting at is this is something with respect to volunteers going into the jails to do certain things, and you're required to sign before you come in. Is that correct?
Yes, sir. Clearance papers. And in the past, for the last 30-some years, it's been about 2 or 3 forms we've had to sign, and sometimes fingerprinting. But now all of a sudden, I don't know if it has anything to do with the pandemic, we've got to agree to this huge manual that is not even provided. One thing that Attorney Longstreet did do, he suggested that the Sheriff Department make this accessible online where volunteers can read it. But again, because of the length of the manual, it still needs to be condensed for people to be able to understand what they're agreeing to be bound by.
I'm gonna let Mr. Longstreet address this. I mean, I would think on the surface, these seems like internal policy things with respect to that particular department, the sheriff's department. Obviously, we have a new sheriff and he may have implemented some new policies and procedures, particularly with respect to coming and going from the jail. And most departments are allowed to issue these policies. If you don't want to agree to them, obviously they can bar you from entering. But again, those are policy issues internal. I don't want to get into that. I'm going to turn it over to Mr. Longstreet and let him address your concerns. But again, I thank you for being here. Mr. Longstreet.
Mr. Chair, one of the things before I seated, because Mr. Thomas had asked Attorney Johnson to follow up on these specific issues, the jurisdiction and the length of the manual, and I never heard no one got back with me. Will someone still be following up on that with the commission's office?
I got a hand up over here. Hold, sir. This is Mr. Slezak. Mr. Slezak, yes, sir.
Felicia Johnson, the commission counsel, is on Zoom and she has her hand raised.
Oh, okay. Ms. Johnson, thank you for being here. I'm going to open it up for you, ma'am, since you are here. Can you hear us?
I can. Good morning to this honorable body. With regards to the issue with this complaint, we did, Tim Johnson and myself did speak to the Reverend after your last meeting. As I indicated to the Reverend after that last meeting, Tim Johnson will be taking the lead with regards to contacting the sheriff's office, which he did indeed do. I also indicated to the Reverend at that time that because the sheriff is a separate official, there's no one who has jurisdiction over him to force him to do anything. All we could do is to assist him on behalf of the commission was to reach out to the sheriff's office to see what, if any, information we could get. We actually did do just that. If the Reverend has indeed left me a voicemail, I apologize. I'm looking at my phone now. I do not have a voicemail. My office phone connects to my cell phone. I will check my office phone when I get into the office and return your call. But the county commission did indeed follow up with the sheriff's office as indicated, and the information I provided you after that last meeting still stands. No one has jurisdiction to force the sheriff to do anything, but we were simply trying to reach out to see what, if any, additional information we could get. And Mr. Johnson, again, was that contact person, and he did do that. Thank you, Chair Pinkins.
Thank you, Ms. Johnson. Mr. Taylor, did that answer some of your questions, sir?
Not partly it did. First of all, within the last 2 or 3 weeks, I left 2 voice messages. And I got her voice on the voice machine. I left them. Secondly, it was specifically stated that she would be checking with the county commissioner to see if anything could be done in that kind of a situation involving the sheriff's department. That's what I was waiting to hear, some kind of response to that. I never got that. I heard them say they contacted the sheriff's office. Basically what Mr. Johnson told me when I talked with him, he was supposed to get back with me within a week. I didn't hear from him. I had to call him to find out what was going on. But he told me, I talked with the sheriff's department and they said that they have spoken to you a number of times about this issue. Okay, what news is that to me? That's why I filed the complaint, because I had gone to the sheriff's office.
Well, Mr. Taylor, I think what Ms. Johnson just said is that she spoke with the commission. And she said the commission reached out to the sheriff's office to see what could be done. But she is saying that they don't have any authority to force him to change basically his policy and procedures, what he has set up within that department. That is his department that he's over. They don't have the authority to force him to change that. That's what I believe her response was.
Okay, she checked that out. And that wasn't really my initial request. They offered to do that. If anything, my request on the questions that I would pose even to the whole ethic board right now at this point, when it comes to jurisdiction over a situation like this, since the ethnic board is not able to do anything, how about the 3-person panel? The prosecutor, the clerk, the judge, they appointed this person in this office right now, or even the executive, Warren Evans. Are they in any way, would they be able to address a situation like this? The ethics board can't do anything?
Well, again, I don't want to, this board does not want to speak on that. I mean, you have to look at who would be over to have the authority to do that. And what Ms. Johnson just mentioned is that there's no one that really have the authority to do something like that. Again, it sounds like this is a policy and procedure, internal policies that the sheriff has set up for their internal operating procedure. So that's within their right to do that. Particular department may set up particular, and again, I'm not being quoted on this. I'm not stating this is a fact. But what I'm saying is generally you have departments that set up internal policies. And if this is their internal policy that you sign certain documents before you come in or you can't come in, then that's a policy that they set up. And for someone to say that, well, I don't agree with the policy and someone should force them to change it.
No, sir, I'm not saying I disagree with the policy. What I am saying, it is not practical to have an 1,100-page manual and give it to volunteers and said, you have to you are bound by this. You have to agree to be bound by this. And people don't even know what's in the manual, where it is, or they don't even have access to the manual. That's what I'm saying. That's not ethical. And matter of fact, even the board themselves, that's why they sent the letter to the sheriff saying that's their recommendation. There's some kind of modification. People do have the right to know what they're holding themselves accountable to. The board sent the letter out to the sheriff saying that.
Mr. Longstreet, do you have anything to add to what Mr. Taylor has just addressed?
I do not. The letter sent to the sheriff did spell out the board's concerns of fundamental fairness in not providing citizens with information that they're requiring them or provisions they're requiring them to be bound to. So we did agree with Mr. Taylor, Reverend Taylor. That information was sent to the sheriff's department. However, I'm not really sure how to redress Reverend Taylor's issues in that we've done everything we can do to resolve those issues. There's no one else we can go to. There's no one else who has authority to do anything in regards to the policy. And I'm trying to get a little bit of clarity so we can really help you out in regards to what the real issue is, because we have a response from Chief Dunlap that talks about you can't perform religious services in the jail. Is that the real issue, or is it the issue that you just simply don't like that you were told that you had to abide by what I believe is a 490-page manual of the NCIC that has particular provisions that really only do anything but secure the jail? So is the real issue you're not allowed to preach the word?
No, sir.
Which we can do something about.
No, sir.
Versus them not, may I finish, sir? May I finish? Thank you. Versus the jail having you abide by provisions that they haven't told you about. However, it seems to be at this point that you were clairvoyant enough to go online and read it yourself. So you know what the provisions are. So do you have a disagreement with what you had to agree with?
First of all, the last email that I got from the sheriff's department from Chief Dunlap, thanking me for my years of service, volunteer service, and informing me that if I should change my mind, in other words, agree to these documents, I'm welcome back. So there's no issue with us in that regards. All I'm trying to do is get some clarity on what they're expecting us to do and be bound by.
May I ask a question, sir?
Sure.
You have read the NCIC manual.
Sir, it is 1,100 pages.
I understand.
No, I haven't read it. No.
Okay. Is there any portion of it that you disagree with?
Any portion of it? I have not read it, sir.
Okay, I understand. And do you understand that the NCIC is just simply a manual that provides security and or provisions of security to the jails?
That could be true. Yeah, but what I'm saying, I'm not arguing against the manual. I'm saying the length and what pertains strictly to volunteers. Matter of fact, at the end of the form, and I mentioned this last week, at the end of the form they wanted us to sign, it had, this is for contractual workers. I'm not a contractual worker.
Understood. I guess my issue is your issue that you weren't told of the specific provisions, or you have a problem with the provisions themselves?
The length of the manual, I've repeated it several times, the length of the manual that we're expected to be bound by and adhere to, that's the issue.
Let me just ask this, Mr. Young. So are you saying, I understand the length of the manual. Are you saying if someone explains it to you, they sat down and went over the manual with you and then said to you, okay, we've explained the manual to you. Now you have to agree to sign to come in. This is an agreement between the two of you that you're going to be bound by what you've just been explained in this manual, and you're going to be allowed to come into the jails. Are you saying that's the issue, that you were never explained what's in the manual, or are you saying you have problems with the manual itself, that you have to be, this manual, you got to sign, to be bound and everything in this manual? I mean, I'm trying to understand what
the fact that they seem to insult the intelligence of the volunteers is telling us that in order for you to come in to do your volunteer work, you've got to agree to all these documents, but don't show us the documents, including this manual that I'm talking about.
So it sounds like what you're saying is you wasn't shown the manual.
Exactly.
So if you were shown the manual and explained the manual, then you would have no problem signing it to come in. Is that what you're saying?
Yes, sir.
Okay, Mr. Longstreet.
I believe that's what the board suggested, that the Sheriff's Department provide that information to the volunteers and or provide them a place where it can be found. So I think that issue was addressed specifically. I think it's best practices that the Sheriff's Department outline it in short bullet points, the specific provisions that they really want to highlight in this NCIC, because I believe it's be a 490-page manual. However, either way it goes, it can be shortened so that the Sheriff's Department is specific in regards to or highlights the specific provisions that they want the volunteers to abide by. However, this board has fully and properly addressed the issue of Reverend Taylor.
Have you sent that letter out to the Sheriff's Department?
Mr. Taylor, let me just stop you for a minute. I think Mr. Board Member Young has a question he wants to.
Thank you, Mr. Chair.
Yes.
I remind you that when this matter first came on the agenda before us, I think we reviewed it. We recognized at that time that this was something that we didn't have jurisdiction to address. Yet at the same time, some of us were a little frustrated because we had the gentleman that was performing services, charitable, religious, whatever, good services to the public under trying and difficult circumstances. And we wanted to send a letter, make a suggestion, maybe stick our nose into something that maybe we really didn't have any right to do. But in any event, we thought we would at least try and suggest that if there's a way to put this together and allow him to continue, because he's doing good, at least we thought that was the case, we thought that might be helpful. Nothing, though, I think has changed since our initial review and our initial decision as of today. I know the gentleman's very frustrated, and I certainly support the effort that you're engaged in the jail. It's like I said before, meetings ago when we first heard about this, you're doing something that I guess I'm not willing to do. And yet at the same time, we recognize that benefit and that value, and we wanted to do something to help, but we just couldn't. As I understand it, the Wayne County Sheriff, the Wayne County Treasurer, the Register of Deeds, these are all constitutionally created positions. They're independent of each other. They run their own offices. They have to abide by certain federal restrictions and the like, and maybe some mandates, but nevertheless, Wayne County Executive doesn't have jurisdiction over the sheriff, nor the Register of Deeds, the treasurer, and the like. So we certainly, this board, doesn't have the ability to do that either. And it just seems to me that the discussions we're having are sort of circular in nature. And whether it's 1,100 or 400, I mean, I certainly wouldn't want to have to review that and understand it and process it either. But as somebody had mentioned, this is a procedural matter that was adopted by the Sheriff's Department for whatever reason. unknown to us, and maybe it's not something we need to know. And I just don't think there's much else we can do. I mean, we gave it the effort. We support you, but to pretend that we have some ability to go forward here in any constructive way, I just, unless somebody can tell me otherwise, I just don't see it.
Thank you for that, Mr. Young. And I think the chair is going to mimic a lot of that. I just want to ask Mr. Longstreet, because I know they sent over a letter, the sheriff sent over a letter. He did not address the issue with respect to this manual that's you're supposed to sign. He just mentioned you're being allowed to come into the jails to administer your services. Did we get a response, or at least know who we sent the letter to? And was there any response back from anyone who said that they received it, whether or not they adopt the recommendation or are going to consider it or not? Just any response that they had received the letter?
I did receive a response from the Wayne County Sheriff's Department in reference to this. They did indicate that they would be addressing the issue with Sheriff Washington. I haven't received any other correspondence other than that. I did receive something from Chief Dunlap, but I just received that as part of the ethics agenda.
Thank you, Mr. Longstreet. Mr. Taylor, again, I think you've heard the discussion from the board members. I think this board has tried to address this the best that under our ability to do so. As was mentioned, we don't have authority over the operating procedures of various departments. They operate their procedures pretty much autonomously. They set it up there themselves. We don't have, unless it violates the ethic ordinance. If it's something that violates something ethically, then we can get involved. Other than that, this seems to be an operating procedure. You do raise a valid issue, because if someone is requiring you to sign something that has not been explained to you, then that becomes a valid issue, and particularly if it's a lengthy document and you're required to sign it. However, they're requiring you to sign it to come in. You could either sign it or you don't come in. And I do understand that departments have to protect themselves, and they may have, particularly with the sheriff's department, with respect to the jails, they have a lot of issues concerning inmates, security. So it's a lot of things they have to be concerned about. And I'm sure that document has a lot of those things in there. The best we could do is pretty much send them a recommendation, asking them to at least explain it to people when they come in. And I can also see where that might be difficult, because a document of that size, I'm not sure if they would have the manpower or have someone paid to be able to sit down with each person that comes in and performs, whether a volunteer or a contractual position, to explain everything in that document. I mean, that would take a considerable amount of time. So you can understand where they may not have the resources or have put forth their resources to explain everything. We can make a recommendation, which we did, that they possibly outline some of the stronger points and maybe explain that before requiring a person to sign. But again, it's totally up to them if they want to do that. Again, we don't have the authority to force them to do that. Again, these are operating procedures that they've enacted within their own department, and they are allowed to do that. So long as it doesn't violate the ethics ordinance or anything ethically that we can look at. Go ahead, sir.
Well, I appreciate the feedback that I've gotten. Even the fact that they responded to Attorney Longstreet, the letter that was sent out, that's encouraging that they did that. Sounds like they're aware of the situation and there could be some possible changes made. My question is, the letter that was sent to the Sheriff's Department, when will I be getting a copy of that letter?
I guess the issue is we are, and you've been sitting during the meeting, that we are addressing that issue, whether we should disseminate those letters or not. That issue has been tabled for the next meeting to determine whether the complainants can remain anonymous or whether we have to provide the information pursuant to the Open Meetings Act. So upon me doing homework on that and the board making a decision on whether those letters should go out or not, and it's officially voted on, you will receive that letter. However, that topic was discussed today and has been tabled until the next meeting.
From what I understand, it was referring to persons that wanted to remain anonymous. That's not my case. I mean, I don't have any problem at all with the sheriff know who's filing this complaint. So I just want to know, when can I receive that letter that was sent to the
No,
department?
no, what he's saying is that we haven't addressed that issue. There was an anonymous component in there that we also raised, but everything that was going to be discussed at the next meeting and research is whether or not we'll be providing a copy of a letter to respondent or not. So that's an issue that's still up in the air that this board hasn't decided upon.
If I'm in attendance next month at the next meeting, do you think that issue will be resolved and I can get a definitive answer on this?
Possibly, it may be. There's no guarantee, but it may be. Obviously, if you are allowed to attend, and we will welcome you to attend. I'm not saying whether or not you will have your answer at the next meeting or not. However, we do look to resolve issues that come before this board very, very, in a very timely manner. But I can't assure you that you will get a definitive answer at the next meeting. You may not. We may address the matter. It may be resolved. It may be moved and adopted. We don't know at this point. Still, this is a matter still for the board to discuss.
Okay.
Well, I can tell you, for purposes of transparency, that what I told you is what I told them. And so what's contained in your letter is also contained in theirs in regards to what I believe they should be doing. That is fundamentally fair. That you should receive that information, that if they're going to have you abide by certain provisions, that they should provide you a copy of those provisions and or provide you a website where those provisions can be found. So for purposes of transparency, to fulfill your inquiry, what I would say to you, I said to them.
Thank you for that, but I still would like a copy of the letter.
Mr. Longstreet, we're gonna move on, Mr. Taylor. And again, I'm not. I don't want you to feel like your concerns are not being addressed. We do have other matters on our agenda that we have to get to, but I wanted to make sure that we heard you since you're here and you've been patiently and then you've been diligently pursuing this. And I agree. I understand that this is something that's very concerning to you, which it should be. But we do have other matters we have to get to. I'm going to let, I think Mr. Thomas have a question. Mr. Longstreet may have follow up with you, but we're going to have to move on. Mr. Thomas, I'm going to.
I just wanted to sort of emphasize, I think, something that Mr. Young discussed a short while ago. I would say this, whether Reverend Taylor comes to the next meeting or not, his matter has been resolved by us. His complaint has been resolved. The issue that remains right now concerns him getting the letter. If Reverend, if you want to come to the next meeting, our meetings are public. You can come to the next meeting. You can come to all of our future meetings. But I really don't see any need for future discussions regarding his complaint and whether the document that he's being asked to review is 1,100 pages or 400 pages. I think that, as Mr. Young said, we're going in circles here.
Yeah.
So if there's anything else that Reverend Taylor is dissatisfied with, he's heard what Ms. Johnson had to say today. She's going to check her voicemail messages and she's going to get back to him. We don't have authority, and the discussions are not going anywhere. The discussions that I had with you on the telephone, the discussions that you had with Mr. Longstreet, they're not going anywhere. And you're not, and I understand your frustration, but that doesn't make a difference regarding us not having jurisdiction. So I would say that the record should be closed somehow. And if a motion is needed on that, I would make a motion. There's just no need for us to discuss a matter further that we've already spent a lot of time on. I sympathize with him. I think that what he's doing is, we hear talk about heroes every day out there in society. People going to preach to individuals that are incarcerated. I can't think of anybody that's a greater hero than that. But all of that doesn't change our decision that we made months ago that we don't have jurisdiction in your matter. And I say that with all due respect.
I think the chairperson has made it very clear that the issue.
Chairman, if that's a motion, I would support that motion.
I'll make a motion. I'll say it in a motion. I really believe the
Mr.
matter
Chair,
has to be closed
Chair,
at some point in time.
Mr. Chair, you made it very clear that the matter of the jurisdiction, the manual is well dealt with. I'm not even dealing with that now. Only thing I'm asking, and it was stated last month when I came to the meeting that the decision would possibly be made this week to to get a copy of the letter. That's all I'm asking. Can I get a copy of the letter? That's all I'm asking.
So what he's talking about now, he's not addressing his complaint, and we've dealt with the complaint. That
Thank you.
issue is done. What he's asking is about what we're going to be discussing and researching and looking at as this board makes its own adoptions regarding whether or not to disseminate a letter in response to a complainant, as well as to sending that same letter to the respondent. So with respect to that, sir, so your complaint has been dealt with, and that matter is off the table.
Right.
So you're asking whether or not you're going to receive a copy of whatever letters that we sent to the sheriff's office.
That's it.
That matter has not been decided. So, and again, as was mentioned, as you heard as well, you are free to attend as many meetings as you like. We would love to have you. Are open to the public. If you're coming to a meeting thinking that you're going to get some sort of answer as to whether or not you're going to receive a letter or not, that you won't get. You may get something once you find out whether or not we've made the decision to adopt, whether or not we're going to send the letters to respondents and the complainant or not, or you may not. So that's something that we're talking about here now. So, but your complaint and that has been addressed. We've dismissed it for lack of jurisdiction. I think we've explained that this board does not have jurisdiction to order the sheriff's department to change their operating procedures in any way, or to do the things that you're asking them to do. Again, I did give you this time because I do appreciate the fact that you're here, and I understand this is something that's frustrating for you. It should be. But again, they are extending a courtesy to you to allow you to come in. You just have to sign certain documents. I think that's something that they want to protect themselves on. And the issue sounds like you're not being explained those documents that you're being asked to sign. That becomes a little valid, but again, that's an operating procedure that they've put in place. So with that, I'm going to thank you again for being here. Again, hopefully you should continue to stay in contact with Ms. Johnson. Hopefully she may get back to you. Mr. Longstreet may get back to you and give you some follow-up information. Hopefully, I think you should remain in contact with the Sheriff's Department because it seems as though they want you to continue doing what you're doing, but you just have to make sure that you sign and operate under their policies and procedures. Okay?
Thank you, sir.
Thank you for being here, sir. All right, moving right along. Our next order of business, item D, which is new business. We have communications from Mr. Mamata Burgi. I apologize if I'm not mispronouncing the name. He's a Wayne County employee. I think at this time, everyone received a copy of the letter from Mr. Burgi. I apologize. I've just been informed this is a she. I really apologize, Ms. Burgi. I believe everyone received a copy of the letter. And at this time, I'm going to open this up to Mr. Longstreet. Mr. Longstreet, I believe this is an advisory opinion.
It is an request for an advisory opinion. However, it's a request for an advisory opinion. Well, it's not really a request for advisory opinion, but it's just a request of whether they can make a request for an advisory opinion on work matters. I have submitted to the members of the board a proposed response letter that I have drafted that I believe is the appropriate response, and I will open it up for discussion in regards to whether anything new should be added to this letter or changed in response to Ms. Burgi's request.
And you drafted a response, Mr. Longstreet, to her?
I did.
Do you have that response? Do you want to read that response to us while we're here, since Ms. Burgi is here?
I do. The response is, this letter is in response to your August 1st, 2022 email request for an ethics opinion. Section 40.7G1 of the Wayne County Ethics Code provides the following in reference to requesting an ethics opinion. G, ethics advisory opinions. A public servant may make a written request for an advisory opinion if the public servant is in doubt as to whether their conduct is in compliance with the requirements of this chapter. A request for an advisory opinion may be made anonymously. Currently, the ethics opinions are limited to those inquiries specific to the violation of the Wayne County Ethics Ordinance. However, the Wayne County Ethics Ordinance is silent as to your specific inquiry to work matters not related to possible violation of the ethics ordinance. If you believe an issue has arisen that relates to the performance of your duties and responsibilities as a public servant that you may believe require guidance or the opinion of the Wayne County Ethics Board, do not hesitate to bring it to our attention, as we will do our best to address any issues that may be of concern to this board.
Burgee, you heard the response there. Do you have anything that you'd like to ask? She is here. Is Ms. Burgee here? I thought she was here. I apologize. Okay, well, thank you for that, Mr. Longstreet. Does any member have anything to add to that? Or any questions any discussion on this matter?
Well, the only thing I was going to say is, Mr. Chairman,
Yes, Mr. Young.
I think that it is succinctly responded to and stated with clarity, and is exactly the direction that I would expect we would take given the current situation, or given the current ordinance. So if you're looking for a motion to adopt, I don't know what we need to do, but if that's required or necessary, I make that motion.
Any further discussion on this matter?
I just had
Yes, Mr. Thomas.
I had really a question regarding the second sentence of the paragraph that begins about a little over halfway down. The paragraph begins with the word currently. I don't have a concern about the first sentence. I'm just wondering about the wording of that second sentence. If it could be stated more clearly that the ethics code does not address work matters not related to a possible violation. I'm just wondering what effect that might have, saying that it's silent. If the person who gets the letter, if it's going to be clear enough that we're saying that we don't have authority over that. So the way I suggested it when you gave me the letter this morning in my changes, I suggested that sentence read as follows. The Wayne County Ethics Ordinance does not address work matters not related to a possible violation of the ethics ordinance. I think that might make it a little more clear, but I could live with it the way it is.
Are you asking to replace the word silent with does not?
Well, I'll tell you what, I would take out the word however. The sentence would read, the Wayne County Ethics Ordinance does not address work matters not related to a possible violation of the ethics ordinance. So the phrase silent as to your specific inquiry too would be taken out.
Okay.
But I'd like to see how other people feel about that. If people feel that the letter is fine, it's fine.
Mr. Chairman, if that is deemed more clear, that's fine. I mean, I would amend the motion to include allowing or approving the letter subject to Mr. Thomas's suggestions, and we can move on from there.
Second that motion.
All in favor?
Aye.
All opposed? The ayes have it. So moved. All right, moving on to the next item of business, and such item E, which is such other matters as may be properly submitted for this board at this time. If there is any other matters before this board at this time. There's no other matters before this board this time. We're going to move to item F, which is public comments. Are there any public comments at this time?
All lines have been unmuted. Commission Counsel Johnson, hand is up.
Yes, Commission Counsel Johnson.
Through the chair to this honorable body, during this meeting, the body has indicated that you will be reviewing matters for further consideration. And I just wanted to provide some additional information for your consideration as you look into these matters. As I previously indicated to this board, the Wayne County Commission considered whether or not complaints can be made anonymously when it adopted the ordinance. It ultimately adopted an ordinance that requires under section 47C1 that all complaints must be notarized. So individuals must identify themselves in order to submit a proper complaint. It also indicates in section, I believe 40-7B4, that to the extent provided by law, the identity of the complainant can remain confidential, but that's only to the extent required by law. At the time that the ordinance was drafted, there was not much law that would allow for that identity to remain confidential. but the commission added that language to ensure that if there was a law that allowed for the identity to be confidential, that that option would be available to the board. In addition to that, the commission did add specific language in section 40-8 about whistleblower protection, indicating that employees will not be retaliated against. So I just wanted to bring all of that to your attention. Again, the ordinance actually requires that under 47-B5 and other sections, that all information provided by the complainant and all information provided by the respondent are to be provided to the other parties. And then you should also note that this board is subject not only to the Open Meetings Act, but also to FOIA. So all documents created by this body is subject to FOIA, and unless there is a special an exemption under the FOIA statute that would require that a document not be produced publicly if requested, then that document will be produced under FOIA unless there's an exemption. And I'm not aware of any exemptions specific that would cover some of the actions of this board. But again, I present all of this for your consideration as you continue to deliberate the matters before you. Thank you.
Ms. Johnson, from the chair, can I just ask you a quick question? Because you addressed a few things, because in the ordinance, it does say that there's a whistleblower a portion in there. However, the ordinance, that's one of the reasons that we're adopting some of these amendments, or we're looking into some amendments, because the ordinance does not say what the penalty will be for any sort of whistleblower or any sort of person who, is deemed a whistleblower if they receive some sort of retaliation. It doesn't say what would happen. It mentions the whistleblower protection. It does talk about anonymity, but like you mentioned, it does require the complainant to have the complaint notarized. So the anonymity is sort of a contradiction, because you're notarizing something, but then you can also remain anonymous. Is that saying that you can just redact your name, or your name does not have to be presented to the other party? And also under FOIA, I think certain situations, FOIA, some things are not to be disclosed even under FOIA, particularly if a person wants to remain anonymous. The names can be redacted, addresses, things like that. So are all those things to just be assumed under the ordinance, or is that something we have to seek the commission for more clarity on?
So through the chair, you've raised a few points. With regards to anonymity, the ordinance does not allow complaints to be submitted anonymously, only advisory opinions. It is very clear and very specific that advisory opinions can be submitted anonymously. However, it is also very clear that in order to submit a complaint about a potential violation, that complaint must be notarized. That person must identify themselves. There is a provision, again, 40-7B4, that says, to the extent provided by law, that the identity of the complainant can remain confidential, but you need another law in order to allow you to do that, and I'm not aware of any such law. With regards to FOIA, there are numerous exemptions under FOIA that would allow information not to be provided. However, the identity or a person's name is not one of those general exemptions. The exemption with regards to your address, your social security number, that's considered personal information that can be exempted under the exception for the personal information and the it's not called confidentiality. I can't remember the exact wording, but it's about the not disclosing your personal information. So your social security number, your address, we do as a county redact that information and not provide it, but that does not include a person's name. Again, if this board reviews the FOIA, the act, and you determine that you think there's something in there that would allow that, then obviously that's the determination and discussion to be had. I'm not specifically aware of it off the top of my head. And we were, when this ordinance was initially adopted, again, those discussions were had and those considerations were considered and thought through at the time.
And with respect to the whistleblower portion of the ordinance, does that provide just the person to sue, bring an action legally? Or is there any action to be taken if there is any retaliation against a particular employee because they filed a complaint or took some sort of action? Because the whistleblower doesn't explicitly say what would happen if there's some retaliation taken. It just says whistleblower protection pretty much.
That is very true. It does not specifically speaks to that section regarding specific penalties. Obviously, an individual has every right under the law to sue and pursue other remedies provided by law. While there are penalties under this ordinance, I can't tell you that I think those are specific to the whistleblower protection. Now, can the county, have some type of, I want to call it, can the county, if it's determined that an employee or director has violated the ordinance or retaliated, there are obviously things that the CEO can do if it's someone on his staff in order to discipline or to address that matter. But you're correct, that specific section does not specifically speak to any penalties specifically related to whistleblower. Though we do know there are some options available like lawsuits. And again, the supervisor, such as the CEO, could always take some disciplinary actions.
Thank you for that, Ms. Johnson. And as I mentioned before, that is an issue that I think this board needs to look at with respect to our amendments, because I do think in some of the cases that we've had in the past, when people have raised complaints, if you're raising a complaint against your against your employer, that becomes serious. And just to have something that says whistleblower protection with no sort of protection for that person, it can become a matter for a person not to want to do that, because this is your employer. I mean, this is you work for the county, you work for this particular department. And if you're bringing something that you've seen against your boss or supervisor, that could be something that's discouraging. And without any sort of protection, and when you have what we mentioned before, people doing their own investigations to find out matters, how can they actually prove a case of whistleblower when, if they can't investigate and find the documents to even prove a case like that sort of civilly. So that does become a concern for the chair at this time, and for this board, with respect to people bringing complaints within the county and against their employers and that, or supervisors in various departments. So with that said, is there any further public comments at this time? Any other public comments at this time?
I don't see any more hands, and there were no emails.
Okay, thank you for that. All right, if there's no further comments from any board members, the chair will entertain a motion to adjourn.
Motion to adjourn.
All right, the motion is to adjourn is on the floor. It has been seconded. All in favor?
Aye.
All approved.